Right, Murtala, what have you got for
Yes, so I've
today?
got a lot for you yesterday. The Supreme Court. It was a busy day at the Supreme Court, especially where lawyers of the Akwatia MP, the embattled Akwatia MP, appeared at the Supreme Court, and we know the controversies that have surrounded his election so far. The High Court in Koforidua has convicted him for contempt, and a bench warrant has been issued. So yesterday, his lawyers, led by Gary Nimakuma, were at the Supreme Court. The interested party, Henry Boachiyi-Adom's lawyers, were also at the Supreme Court. Of course, the EC's lawyers were also at the Supreme Court yesterday, and a panel of 5 presided over by Justice Gabriel Puama sat on the matter. And interesting stuff happened yesterday. The first of it was that there were certain processes that the applicant wanted to serve on Henry Boachiyi-Adom, but we were told that he's not in the jurisdiction now, he's traveled. And so they made the prayer by way of a substituted service before a single judge to have the processes served on his lawyers, and the court granted that. So that particular supplementary processes were to be served through his lawyers. Then the issue about the motion for certiorari to quash and prohibit the judge from dealing with the contempt matter and all of that. So what has happened is to the effect that, look, the court's moment when Gary Nimakun, who is counsel for the applicant, Ernest Yaokumi, was in the process of moving his application, then he got stopped. Justice Gabriel Puama, who presided over the panel, said that, look, at this particular point in time, you are before the court to move an application of this nature. But as it stands now, your client is in courts, at the High Court especially, but he has not subjected himself to the rule of law. So on what basis are you coming to the Supreme Court for the Supreme Court to deal with the issue? All the court here deals with the issue or run with the rule of law. So even if the decision taken by the High Court is wrong, what you have to do is that you take steps to purge yourself out of contempt. You take steps to respect the laws or the orders of the court. If you disagree, the channels are there for you to follow. So as it stands, we cannot grant you the audience. The Supreme Court cannot listen to you because we think that you have not fulfilled or showed respect to the rule of law. So the Apex Court cannot take a decision that the court below or the other lower court below it will say that, oh, the Supreme Court has taken a precedent that for them it doesn't augur well for the rule of law. So yesterday it became forth and back. Gary wanted to justify why the court of the High Court, they have not appeared at the High Court and all of that. But it got to a point the panel realized that where things were going, they were not going to grant him audience, but they retired. And then when they retired to go and deliberate on the matter as to whether we grant them audience or not, they came back and said, look, what we have said is what will stand. However, we think that you should come and address us. The party should come, especially the applicant should come and address the court why they should be or he should be granted audience by the Supreme Court. But the Supreme Court think that we are even doubting to accord our right to hear him and all of that because he has not subjected himself to the rule of law. And that is the same rule of law that the Supreme Court deals with. And an issue is happening at the Koforidua High Court. You haven't gone there to purge yourself and you are at the Supreme Court. The Supreme Court will not be able to take that decision. So yesterday, it was very interesting when the case was adjourned. But however, when the case was adjourned to March 4, the lawyers made the point that as it stands, when the man is arrested by way of the bench warrant or he turns himself in, the judge is going to sentence him. So they want the court to put an order on the court until such time that the matters at the Supreme Court is dealt with. And the court said, look, once that has happened, we think that when we make that order, it means we have heard you. But in the interest of justice, we are going to ask the High Court in Koforidua to hold on with the sentencing. And then until after March 12, when the parties deal with the issue, then we can move on and all of that. So let's hear from Alexander Afenyomarkin, who represented Ernest Yaokumi. He personally was not present, but he was represented by Alexander Afenyomarkin. Let's hear him after the court sitting.
And the process is going to be served on his counsel, who was in court. So once the council is set, then we move a next step to determine the matter regarding the conduct of the court, i.e. praying for an order of prohibition. Of course, there was another matter that the court took a view that parties should address it on saying regarding whether or not the honorable member for Akwatia ought to submit himself to the jurisdiction of the court prior to seeking the court's jurisdiction or audience in the Supreme Court. Well, counsel for Ernest argued among others that the court is always a court of record. And when we hear matters on social media, particularly so when Mr. Kumi was not in court, had actually written to the court that he will be absent because of parliamentary commitment. He cannot just walk to the court and say that I've submitted myself merely because he has something in the air. As we speak, there is no such order from the High Court, Koforidua, ordering him to do A, B, C, or D. In fact, the Speaker's Secretariat has not even been served with any process, which process would even invite Speaker to release the MP.
So that is Alexander Afenyo marking after the Supreme Court sitting yesterday. But of course, Bernard Bediakon, counsel for the interested party of the NDC, has also been speaking.
There was an issue with regards to whether or not the contempt, who is the applicant in the instant application, should even be granted a hearing at the apex court of the land. And their reasons were that there was a matter that they were aware of that he was convicted on with regards to a contempt application that was filed against him for his disobedience to the court orders and GHOne in as member of parliament. So the court was of the view that when it is like that, the sanctity of the court is at stake here. And so you cannot run to the Supreme Court when that process is not ended and then have the Supreme Court, as it were, whitewash you of your sins. And so they were of that opinion, but they had to retire and then confer and come back. And when they came back, their view was that we should address them on the law with regards to such issues. When it happens, what should the Supreme Court do? And so we've been given 7 days to file a statement with regards to the law, and then they would look at it and give a decision on the 12th of March. So on the 12th of March, we are back here to determine whether the applicant can be given a hearing in the apex court of the land. And prior to that, we will file our written addresses for the court to take a decision.
Who was representing the NDC candidate in there. So on the 12th of March, they'll be back to address the court whether he should be given a hearing order. And so yesterday, Deputy Ministerial appointment vetting at the Parliament yesterday, and one of our interests this morning is Dr. Justice Remsai, the Deputy Minister for Justice and Attorney General, was there. And the drama, let's hear from what happened in Parliament yesterday when Dr. Justice Remsai was facing parliamentary vetting.
If you decide to be whimsical and capricious, it will not advance the work of this committee. Apart from the constitutional issues involved, it is also about our culture. We've had nominees speaking their dialect here. Honorable nominee, so you, Chairman, with respect, if my opportunity to ask my questions will be interrupted. The Ghanaian people have had problem with the way we did our things. It is not this time that the chief whip will be applying for. I want to do a follow-up. Let's stop this. We've had a smooth 2 days. where the chair, your deputy, stood his grounds. What is this interference that he needs to do? Follow up. If he wants an opportunity for himself, I'm ready to stop so that you give him the full time to ask his questions. This thing of follow up, it's not acceptable.
Honorable Leader, you know, we recognize the follow-up question. The majority chief whip prompted me, he has a follow-up. So I'll have to listen to the follow-up question. If really it's not a follow-up question, I will overrule him. So please.
Yes, interesting stuff there. So, I'll take on a vetting yesterday.
Afenyu marking being Afenyu marking. That's my take on it. But it was interesting.
Yeah, very
you know,
interesting.
it was interesting. I think it was one of the vetting.
I learned some few things yesterday about how when you appear before a panel, you are able to conduct yourself and answer questions straight to the point, and you are okay.
Okay.
You just have to be as simple as anybody else, and that is one thing that I saw about Dr. Justice Shrem's side yesterday. He was so simplified. All the questions he gave the answers, and he was not trying to. He gave the exact answers, and then he moved on. Very interesting to see the reaction also. He should dancing and all of that. What's your favorite dance?
I don't know how to dance, so I don't know how to dance, so I don't have a favorite dance. But I like to see people dance, though. I must say, it excites me.
We are in the same boat. You know, I'm a
it
very
excites
bad
me.
dancer, yeah.
I can jump around, you know, when I'm excited, but I really don't know how to dance.
I
so I don't
saw
have
a few
favorite
about
dance.
you doing the Daddy Lumes.
Yeah. Those ones I can do very well.
I enjoy the dancing moves and all of that. So that's what happened at the vetting yesterday. And one thing that we also want to share with you is yesterday, Richard Delasky and his lawyers were at the Supreme Court seeking a review of the dismissal of the anti-gay case that he filed at the Supreme Court. But he realized that he cannot push on the gay. So he withdrew that particular motion even when the Supreme Court judges were not happy. They said that you have assembled a panel of 9 and you yourself did not show up. The panel, in fact, did not take it lightly. But his lawyer, Akwatia MP, has been speaking moment after they withdrew the action and it was struck out.
The mark of our practice is the development of Ghana. We are not practicing law just for the sake of practicing. Our foremost concern is the development of this country. One of our grounds for pressing this matter and contesting it up to this point was because it is a private member motion.
Right.
But if you've been following the news, His Excellency the new President of the Republic did not hesitate to indicate that he will ensure that the bill is introduced by the executive, reintroduced by the executive.
Yeah.
That totally makes our contention moot. So if it's going to be reintroduced by the executive, then there's no point pressing the matter before the court. But at the Supreme Court, I cannot say this because it is a political twist.
Right.
And it would have invited different arguments. So the furthest we can go is to get our clients to withdraw the action. It's unfortunate he's not around. The rep could not make it, and that is what landed us a bit in rough waters. But we sailed through, and we give thanks to God. So please, pray essentially, this is the position.
So that Akwatia MP counsel for Richard Sky yesterday when he appeared before the Supreme Court. The Supreme Court was not happy, but it is what it is. They have withdrawn their own action. And Sewa, this morning, the High Court will be supervising the jury selection of Richard Appiah, the man who is facing charge for allegedly murdering 2 kids, teenagers, chopped the body part and stored them in the refrigerator. That case is coming up today. And so these are some of the things that we should be looking out for. And that's all we have for you on court today.
Thank you very much, Murtala Inusah, for bringing us court today.